All right, well, my name is Dr. Justin Spees, and I'd like to bring a couple of things to your attention that are going on here in Elk County. The first one is the county attorney, Jill Gillette, has been lying in court about me and one of my friends about having medical information for someone involved in a trial that we do not possess, never had. She's also said that we put it out online, which again is false because we don't have it, never had it. And she freely lied about that on the Zoom hearing for that case of Robert Walker being unlawfully arrested here.
The defense wants additional medical records on these two officers, but they have been leaking the medical records of the officers to media personas and press, violating their HIPAA rights and their privacy rights. The MRI has been leaked along with other stuff to online media personas. The defendant has encouraged them to go out and find the videos of the court that are on YouTube, such as today, where they made a public announcement wanting everyone to watch and make comments on it. The live stream for today, it is running rampant with death threats against everyone. But more importantly, they have leaked information about Deputy Watts's history past. These media personas are trying to go into detail about anything from former Deputy Watts's history of his medical care, trying to obtain it, talk about it. The MRI is being discussed on public YouTube streaming by these media personas that have been leaked by the defendant and his people that are working with him. They have been harassing, following the deputies. It's not appropriate. The leaking of his personal medical MRI to these individuals who are discussing it publicly live on YouTube videos to get likes and hate messages and stuff out there is not appropriate. That is protected healthcare information for Deputy Watts that are required to be turned over. The discussions of his herniated discs, his physical therapy, all of the stuff that would be contained in his protected healthcare information should not be being leaked out to these media personas who are discussing it in detail, even going back to his records in Arizona and discussing whether or not he had medical things in Arizona is being discussed, or where he has previously lived, trying to obtain his medical history based on the information that they have gotten off of the discovery that's already been given. The leaking of this discovery has been egregious by the defendant. He has allowed this deputy's medical records to go onto live streams. That's not appropriate to the victim in this matter. Whether the victim is a law enforcement officer or not is immaterial to his privacy of his medical records, except for within the jury trial where they may have to be introduced into evidence. But pre-trial leaking of his personal information, including the things that would contain his personal identifiers, is not okay. And at this point, what I have in my possession needs to be looked at under a sealed camera. If it has to be given to an expert, an order protecting that has to be done. I talked with Mr. House and told him that I would be filing this motion because of everything that's been going on and the harassment and the more recent posts that have been going on. This stuff has amped up in the last 2 weeks with live streaming in the courthouse, harassment of witnesses and trying to intimidate people, including the state. No, that is not okay. And Mr. Watts, former Deputy Watts, his healthcare information needs to be protected. If an expert wants to look at it, the expert could have it to look at under seal to not be disclosed further, but I do not believe this defendant needs to have it in his hands. And if Mr. House is given it, he should never disseminate it further to the defendant because of the actions of the defendant. He has created a new Facebook group within the last week and has been posting all kinds of slanderous stuff on there that is not true. And there needs to be a seal on any further record disclosure of Deputy Watts or Amy Bliss's medical information before it's turned over, because this has gone rampant and is not appropriate. And all of these social media presences have copies of all of these videos and have been running them on websites like crazy. That all of that has to be,
Go ahead.
all of that has to be protected and not disseminated. Any medical records in anyone's possession other than Mr. House should be destroyed. It should not be out there. It should not be further disseminated anywhere. The medical records, if I need to give them to Mr. House for his expert, should not be disseminated further than Mr. House or the expert. It needs to be under complete 100% seal. I would prefer they have to come look at them because of what's happened with all the leakage of stuff out of this case. I mean, the videos are being edited. They're being still shot. They're being put on social media daily. All of the witness statements and the affidavits are on the website. The actual victim witness statements to the disorderly conduct of the personnel of the Elk County. And we're not talking about deputies. We're talking about office staff in the other offices that are employees of Elk County have been leaked and are on the public websites. The paper documentation that Mr. House gave his client of his case to look at have all been leaked on these public websites. The victims' names and information should not be out there before trial. The copies of their statements in their handwriting should not be being posted on public websites. That shows how much of the paper documentation has been given out and not just the videos, because they're all made public right now, and you can go live on YouTube. And if I have to log in my computer and scroll up on YouTube these sites for you to watch them, we can take time to do that. Or I can send the court the links so the court can click on the links and watch these videos that show.
I don't want to watch the videos.
Stuff.
The only time that these videos are relevant in this court's view is when they're presented in court.
And the victim statements should not be being taken photos of or scanned.
And your position that those are protected documents comes from where?
Judge,
You filed these public charges identifying these people as potential victims in the case. So it's been a matter of public record ever since you filed charges in this case that they're victims in the case.
That are made public. The evidence is the evidence that is sealed until the time of trial. If the court looks at the state's motion, especially in State v. Alston, and that's where the state was leaking evidence, not a defendant. They wanted to sanction the state for leaking evidence, including statements and affidavits. And it is said that only the public record should be distributed prior to trial. What is in victim statements, what is in affidavits, what is in video is supposed to remain confidential until the time of trial. Public information that is gleaned by a reporter in a courtroom being there publicly may be talked about from a public hearing, but the statements, the affidavits, copies of those documents are not to be made public until after the trial is occurred. And they're not. They're being used rampantly in State v. Huffman, the freedom of speech against the regulation. The court has to balance and weigh that. And I quote State v. Huffman. Further, I also quote the U.S. Supreme Court in Gannett Company versus DePascal, which is 433 U.S. 368, 1979, as to proceedings in the courtroom and who is allowed in and who's not allowed in, and how narrowly tailored things must be for rules on excluding people or things from the courtroom or how to protect things. And in this case, those documents are supposed to remain as part of the sealed case until time of trial. The only thing that is public is what are public documents going back and forth in the court's public record. But the affidavit is actually sealed, and the victim statements are evidence, not public documents in the public record of the public court file that you can find on the Odyssey system is what Kansas uses. Our eFlex filings public system is called Odyssey. What's in Odyssey is public. What's in the discovery is not. And the laws and the cases that I have cited in my motion are what shows that that is not to be disclosed until after the trial. If media wants to do some kind of story on it afterward, make a movie out of a case, those documents are sealed until the trial. And the fact that they're being posted out there has allowed these social and special interest groups to have copies of this stuff, addresses of people that should have been redacted by the defense when they receive them, because we have to give the defense unredacted copies. The defendant should have redacted copies, if any. And the problem that we're running into is all of this is being posted publicly on YouTube channels daily. And I've also filed a motion to issue a temporary, and I wanted it ex parte, but I want an injunction of protective order until the final hearing and trial to maintain the status quo. At this point, almost all the evidence is out there from Mr. Walker himself messing with his own jury trial, because him and his family have been talking to, interviewed by, giving information to two social media personas that are posting everything on a YouTube channel and live streaming from the courthouse and in the county. In fact, this week, Mr. Walker's wife was talking all about this case on a live stream, called my office. He's shaking his head yes that they did, and called my office saying they thought they were afraid of deputies because they've been down here making threats towards the deputies, and now they think they're afraid of them because they've made so many threats to harm them and me. 2 weeks ago, as of yesterday, one of these social media followers called my office and asked if I was a Republican or Democrat, which my secretary said she didn't really know because she hadn't asked me, and that they wanted to break down my door, drag me out on the courthouse lawn, and string me up in a tree. That's disturbing, extremely disturbing. And that's what they told my secretary. So I have had to hire extra security to follow me around. And on the court day, I have extra security that is going to follow me around to watch my back so I can concentrate on my job, because I've had 3 death threats in 2 weeks. And the sheriff is having to bring in extra security. So part of my motion is also for additional security for the trial, which the sheriff is already trying to get in.
That's been previously addressed by court administration.
For a limit of recording by press, especially the 2 entities, because it has to be very narrowly tailored, that these 2 entities that keep putting everything on and coming to the courthouse to live stream, that they cannot live stream the jury trial, they cannot broadcast it, and they not be allowed in because they seem to like to sneak stuff in, and that they not be allowed in the courtroom. Now, if you read my full motion, I fully encourage the legal rule following press, especially our local press, that have never abused their privileges to record things, be allowed. I fully encourage the First Amendment for those who do it appropriately.
And the only way anybody found out about the medical information that she's referring to is because she talked about it in the hearing. Nobody would have even known had she not talked about it. The second thing I want to bring to your attention here is that your sheriff and his deputy Love, sitting right back there, have brought bogus bullshit charges against me and my friend Michael here for supposedly interrupting the business of people here in the courthouse. They said that the two ladies working across there made statements that we were intimidating those women to stop them from doing their work there. But we have the whole thing recorded. Nothing could be further from the truth. The ladies were nice to us. We were nice to them. We were friendly. In fact, they were bringing us messages. People were calling in on our live stream. They were bringing us messages, being totally friendly. We were joking around with them. So either those friendly, kind ladies across the hall are lying that we're intimidating them. Or
Hey guys. Hey. Were you the one that was helping us like on the 9th when we were down here? Yep. We're trying to figure out what exactly we've been charged with. We were told that we were somehow harassing you guys. Okay. We were told that we were somehow harassing people here and we've been charged.
I don't know anything about charges. It was the phone calls that we were talking about, not the individuals here.
But Deputy Love has told us repeatedly that we've had a charge filed against us and that you guys had made statements regarding that.
We have not.
You haven't made any statements.
You guys haven't made any statements saying that we've done something wrong?
We were.
That's what we thought. That's what we thought. We were nice. Everyone was nice.
We were explaining about the phone calls.
Yeah, and we understand that.
they were very
And we appreciated the way you guys handled that.
We wasn't talking about the two gentlemen here.
Okay.
Okay.
So.
Great.
All right. That's
Thank you.
interesting. I think that
We
probably
figured.
resolved.
Everyone was friendly. Everyone was nice.
Yeah, have a good one. I think that pretty much clears it up, guys. What do you think?
or you got a sheriff and a deputy that'll just pull bullshit fucking charges because they don't.
Sir, I'd like to raise a point of order.
What is it?
I'd like to call a point of order.
Of what?
I believe on the street the other day, I was threatened with a lawsuit. And I believe once that happens, this should be.
So I don't really care
Sorry.
about that. So
Point of
anyway,
order,
like I
sir.
was
Point of
saying-
order, sir. This is public comment
It is.
period. It's not a
Okay.
period of time for the commissioners to lecture the public. Let the public speak.
I don't really care about any lawsuits that have been brought to you. It has nothing to do with what I'm
Whoa.
saying here. So what I
Whoa.
was saying is
Whoa.
either they're.
Point of order. Point of order. This is the public comment
Is
I have
it,
been
is
period.
it because I
threatened,
said
The
fuck?
commission has
Is it
opened the
because I
public
said
comment
threatened,
period and you
sir.
must allow public
Is it because I
comment.
said
Hold
fuck?
on.
Is it because I said fuck?
Yeah, if we can drop the profanity.
So I can't say fuck? Is that what you're saying?
I didn't say you can't.
What other
I
words
just-
can I say? Can I say shit? Can I
Attorney,
say
please
shit? Can I say
advise.
cunt? Can I say bitch?
Could we go ahead, just finish up?
I would have finished what I was saying if you guys didn't stop me because I said fuck. It's a word.
I was just gonna ask you to be respectful of the ladies in the room. and
Is
profanity.
that disrespectful?
Well,
You know what I find disrespectful, and I wish you guys would find it disrespectful as well, is that you got a sheriff and a
Point of
deputy
order.
up
Address your
there
comments to the
that have
commission.
made charges against me, lied about what I was doing in here and brought charges against me. I find that disrespectful, more so than any word like fuck would ever do. Get some bullshit charges on you and see how that affects you and see if you think that's disrespectful and see if I give a fuck about saying the word fuck in here. The third thing that I want to bring to your guys' attention, and by the way, we got that whole interaction on video, start to finish. The third thing I want to bring to your attention, Commissioner Doug here, is an asshole. He was asked a question by a constituent at the parade, or I'm sorry, by a citizen at the parade.
And you threatened
you
lawsuits.
basically wanted to fight
And you
him.
threatened me off the
Why are you
lawsuit, sir.
interrupting me? Why are you interrupting me?
Did you not threaten me with a lawsuit?
Why are you interrupting? Not that I'm aware of, but why are you interrupting me?
It's on film, look it up.
Appreciate your vote. You have any questions? Thank you.
I'm gonna have a question or two for him about that ordinance. That's for sure.
So do I have any other candidates that spoke to me about speaking?
Hey Doug,
I don't want to talk to you.
That will conclude the microphone
I wanna talk to
portion
you.
of
I got a
our
question.
I don't wanna
to
talk to
you.
I
don't wanna talk to you.
Sir, you're a county commissioner.
Yes, sir.
And you're out in public. You have an ordinance here apparently that requires people to ID before they can get in the courthouse. Do you not realize that's a Fourth Amendment violation? Do you know your sheriff requires IDs to run for wants and warrants before he'll even come out and talk to you? That's a Fourth Amendment violation you can surely recognize, can't you?
Maybe you didn't understand me. Did you not understand me, sir?
No, did you
Do you
understand me?
Okay then,
Okay.
get away.
You're out in public.
Get away.
You're out in public, sir. You're out in public.
Get away.
Sir, you're out in public and I'm
See ya.
asking legitimate questions.
Get away.
You're a county commissioner who apparently has an ordinance in place that we have to surrender our rights to get into the public building.
Go talk to the sheriff.
The sheriff has put it off on you guys, saying that you guys passed the ordinance in 2010 or 11 as a result of some threat.
So do you support
That's what we're told.
Do you support it?
Do you support that?
I'm not talking to you, boys.
Do you
Get gone.
support giving up
Get
your
lost.
rights to
Get
get into a
lost.
public building?
Get lost.
Sir, we're out in public. I'm sorry
Get
that you're
lost.
upset, but you're a commissioner. You're a public servant.
I'm a public servant. Get
Right.
lost. I don't want to talk to you.
That's your public servant, guys. He's running unopposed this year. It's too bad that somebody else didn't run, maybe. But really, we need to understand, are you going to do something about these Fourth Amendment rights violations here in Elk County? You have citizens that are being persecuted for no reason.
Are you a citizen of Elk County?
I'm a citizen of the country.
Why are you so
Of
agitated?
Elk County?
I'm an American.
You're not from Elk
and I'm
County.
here, well, your citizens have asked us to come down here
Which
because of the
one?
rights
All the rest of
violation.
us Which one?
And that's the problem. You guys all want to know who so that you can persecute them. There you go.
Yeah, I absolutely do. Freedom
Commissioner?
of speech is for everybody, not just for Elk County or.
Here's one of your citizens telling you that freedom of speech is for everybody. Are you going to rescind some of these Fourth Amendment violations, sir? That's all
We don't
we're
need to
asking.
talk to you.
That's all we're asking is that some of those Fourth Amendment violations get rescinded.
I ain't doing shit.
So,
You got it on your-
what's that, hold on a second, Doug, what's that gotta do with what I'm saying? You were.
need to be dealing with our
you
counsel, Mr. Paul D.
Specifically did not want to address, he asked you a Fourth Amendment question about this courthouse right here, and you basically wanted to fight him in the street.
I did not answer
You
your
were a
question, sir.
exactly. You
I'm
were
not
an-
going to.
You were an aggressive, hostile asshole.
I'm that way.
For a
And I'm not
simple-
gonna answer your
for a
question
si-
again.
Then why are you, I'm just reporting it right here, why are you getting so defensive about it if you're that way? This should be no news, this should be, hey, that's Doug, man. Doug wants to fight people that say, why don't you
I didn't
support
want
the
to fight
Fourth
anybody.
Amendment? You acted like you wanted to fight him, Doug.
I didn't. Act what
were
you
a
want. Say what you
complete
want. You put your words in my
unprofessional
mouth.
asshole. You made yourself available to the citizens, and when someone asked you a legitimate question about Fourth Amendment.
What part of Elk
rights,
County do you live in?
right here in this courthouse, you immediately turned into.
What part of Elk County
an
do you live in?
Asshole. What part of Elk County do you live in, Doug?
Right here.
What part is that?
2 miles out of town, sir.
2 miles out of town. What part specifically?
You're not a citizen of Elk County, sir.
What difference does it make?
It makes a
Doug?
lot.
Does it really? Does it mean I gotta stop talking, Doug? Is that what it means? Does it mean that I can't
I can
recognize
5
a
minutes,
Fourth
actually.
Amendment violation? Is that what that means? Is my 5 minutes up? Does that count all the interruptions that I've had as well? Do I get that time back?
I'm gonna give you a little leeway.
Thank you, I appreciate it. I appreciate it. And I'll take that time to say here one more time how big of a fucking asshole you are, Doug.
Thank you. I
You're
appreciate it.
welcome. You're welcome. And I appreciate you interrupting me. I appreciate you wanting to know if I'm a citizen of this county during my time to speak. And I'll repeat, I wish you guys were as upset about fake fucking charges in here as me calling Doug an asshole right now. Appreciate it.
Thank you.